Chapter 2, Section 2.1, Consent to Limited Representation. Explained when the brokerage represents both seller and buyer in the same transaction. We now move into one of the most legally sensitive moments in a real estate transaction, the consent to limited representation. This document is executed only when the brokerage is representing both the seller and the buyer, or landlord and tenant, in the same transaction. This is not automatic. This is not casual. This requires informed written consent from both parties. Without proper consent, a broker risks violating fiduciary duties, agency rules, and potentially facing discipline under ARS, paragraph 32, 2153, and AAC, R4, 28, 1101. This section builds directly on our prior discussion of agency disclosure. Now we move from explanation to formal written consent. Identification of the parties and subject property. Precision matters. The form begins by identifying buyer or tenant, seller or landlord, subject property, brokerage firm. This must match the transaction documents exactly. Errors in party names or property description can create ambiguity. In a fast-moving Phoenix metro market, especially in in-house transactions where a listing generates buyer inquiries, limited representation situations can arise quickly. Accuracy is critical. Example: a Mesa listing generates a direct buyer call to Realty One Group. The brokerage chooses limited representation. If the property address or legal description is incorrect in the consent, enforceability may be questioned. Discussion. Question: why must the subject property be clearly identified in the consent document? Answer: because the consent applies only to that specific transaction. It does not authorize limited representation for unrelated properties. Consent clause, the heart of the document. The key language states that both buyer and seller consent that the broker, acting through the named licensee as, will represent both parties. This is informed consent. It must be voluntary and explained. A signature alone is not enough. As professionals, we must ensure clients understand the limitations that follow. There are two structural possibilities: one licensee representing both parties, two licensees within the same brokerage, each originally representing one side. In either structure, the brokerage entity is the legal representative. Even if two different agents are involved, the firm is still representing both parties. Valley example: Shane Dodd lists a Gilbert property. Another agent at Realty One Group represents a buyer who wants to purchase it. Even though two agents are involved, the brokerage is representing both parties. Consent is required. Discussion. Question: if two different agents within the same brokerage represent opposing parties, is limited representation still required? Answer: yes, because the brokerage entity is the legal agent, not just the individual licensees. Duties and limitations. Where fiduciary duties. Change this section is where the shift occurs. The broker now represents both parties but cannot favor one to the detriment of the other. The document makes clear: the broker cannot disclose that the seller will accept less than list without written authorization. The broker cannot disclose that the buyer will pay more than offered without written authorization. Conflicts in loyalty and confidentiality will exist. This is a limitation of fiduciary duties. The broker moves from advocate to neutral facilitator. However, one duty remains absolute: disclosure of known material, adverse facts affecting value. Limited representation does not eliminate the duty to disclose defects. Example: if a roof leak is known, the broker must disclose it to the buyer even under limited representation. Silence would violate AAC R4 28 1101 and the standards reinforced in Hill v. Jones. Discussion. Question: if a seller privately tells you they will accept $480,000 on a $500,000 listing, can you share that with the buyer under limited representation? Answer: no, unless the seller gives written authorization. that information remains confidential. ARS, paragraph 32(21)(5)(6), stigmatized property clarification. The consent form reiterates that certain stigmatizing facts are not required disclosures under Arizona law, including natural death, suicide, homicide, HIV/AIDS, proximity to sex offenders. This statutory protection applies regardless of agency type. However, physical defects or known material issues must still be disclosed. Reasonable skill and honest dealings. Duties remain. Even in limited representation, the broker must exercise reasonable skill and care, deal honestly with all parties. This protects the public and reinforces that limited representation is not a shield for misconduct. Example: if inspection reveals a foundation crack, the broker cannot minimize or misrepresent the issue to push the transaction forward. Neutrality does not eliminate honesty. Client responsibility, protecting their own interests. The document clearly states that broker duties do not relieve parties from protecting their own interests. In limited representation, this warning becomes even more important. Since the broker cannot fully advocate for one party, clients may consider hiring an attorney, consulting outside advisors, conducting additional due diligence discussion. Question: why might limited representation increase the importance of independent legal advice? Answer: because the broker cannot fully advocate or negotiate exclusively for one party. Each party must ensure their own interests are protected. Compensation, separate agreements. Control. The consent confirms that compensation is fully negotiable and governed by separate employment agreements. This prevents confusion. Limited representation does not alter compensation terms already agreed to in listing or buyer-broker agreements. Prior agreements, superseding conflicts. The consent does not replace prior agreements, but supersedes conflicting terms. This ensures that listing agreements and buyer-broker agreements remain in effect while clarifying agency limitations for this specific transaction. Termination, if the deal falls apart. If no contract is entered, or if the transaction fails to close, the consent automatically terminates. This protects both parties from ongoing limited representation obligations beyond the specific transaction. Indemnification, risk allocation. The indemnification clause requires buyer and seller to hold the broker harmless from claims arising from limited representation. This is significant risk management. Limited representation increases the risk of later claims of bias or inadequate advocacy. Valley example. In a competitive Chandler transaction where both parties are represented by the same brokerage, if one side later claims the broker favored the other, this indemnification clause provides legal protection. Discussion. Question: why is indemnification especially important in limited representation scenarios? Answer: because conflicts are inherent, and the risk of later dissatisfaction claims increases. Bringing it all together, limited representation is legal in Arizona, but it must be fully disclosed, voluntarily consented to, clearly documented, carefully managed. In a busy Phoenix metro brokerage, in-house transactions are common. Understanding this document protects your brokerage, your license, your client relationships. Limited representation is not simply a checkbox. It is a structural change in fiduciary duties.